All right, we're going to go ahead and get started again. I'm going to grab one more thing. So I gave a little bit of a presentation or a little bit of a context about myself. I'm Susan Lassell. When I introduced the session, I'm going to skip reading my bio. We're a bit behind on time and I don't want to cut into our lunch too much because it's gorgeous out there and we're going to want to wander around. So I'm going to just jump straight into my presentation. So what I wanted to do is give the group an overview of what to be thinking about if, in addition to CEQA, if there's a federal trigger. And if you are looking at being involved either in preparing documentation or in commenting on documentation, when there are the federal review processes, NEPA and CEQA. So I tend to think of this as the big three on any project that you might be involved with here in California: CEQA, NEPA, and Section 106. I'm going to try to highlight some of the key differences, and then I'm going to also talk about some of the benefits and options for either integrating the three or, at the very least, coordinating the three, and kind of what the differences are in those two approaches. Okay, so picking up on a lot of the things Ken already covered, CEQA applies only to California agency projects or to agencies that derive their authority from the state. It was actually the first of the state laws modeled after NEPA. And there are about 16 states in the country that have done that. And when CEQA is triggered, Section 106 is not necessarily applicable. Where Section 106 comes into play is if there's a federal trigger, and that triggers both the National Environmental Policy Act, which applies to federal agency actions, as well as the National Historic Preservation Act, and in particular the Section 106 section that says that agencies must take into account the effects of their undertakings on historic properties. So typically, if NEPA applies, so does Section 106. So here's a map of those 16 states that have a baby NEPA, as I like to call it. East Coast makes sense, West Coast makes sense. I'm actually not sure all of the reasons why states across the top of the country have baby NEPAs. I know Montana in the early 1970s had a lot of strip mining happening, and I think their state law was in reaction to that. I don't quite know the story on the other states. Somebody asked me that the other day, and I thought, I need to look into that. But there you have it. And what's interesting when we're talking about integration or coordination with the federal laws is that all of the rest of the states, all of these states are subject to the federal laws. So federal agencies conducting programs and projects in any state have to take that into account. So a lot of the precedent that we have for complying with NEPA, complying with Section 106, really comes from a broader base of case studies and previous examples. In California, we're always thinking about California precedents. Maybe we're thinking about precedents at the state level in other states, but it's just a different perspective of how you're setting your thresholds, how you're setting, taking into account previous examples of a similar situation. So typical triggers that would require both the state and the federal reviews, if a California project is receiving federal funds. So all of our Caltrans road projects, housing and urban development projects that are accepting federal funds but are being implemented by a local housing agency, those are examples. A California project just receiving federal permits. So whether it's a Section 404 permit under the Clean Waters Act, I'm sorry, that's Section 10. Nope, Section 404 is Clean Waters Act. Section 10 is the Endangered Species Act. So if you have these other federal permits being triggered, then that's also going to trigger NEPA and Section 106. Or if it's a large project that has involvement by both state agencies and federal agencies. So like the California Water Fix project, which has our Department of Water Resources, as well as Bureau of Reclamation and Corps of Engineers. Or the California High-Speed Rail project, which has both the California High-Speed Rail Authority and the Federal Railroad Administration. Those are examples that trigger both NEPA and Section 106, as well as CEQA. So, we talk about CEQA being the first state law that emulated NEPA, and as a baby NEPA, you really can see that when you start to sort of diagram out how you implement the laws. The process for stepping through is so very similar between CEQA and NEPA, starting with the idea of doing an initial document that lets you know whether or not you need to do the more robust environmental review, and even the idea of notices at the beginning, scoping meetings, doing a draft environmental document that then must be made available to the public to comment on, et cetera, down the line. Interesting thing that I'll harken back to in a little bit, in both CEQA and NEPA, the requirement for public input really is a requirement for disclosure of environmental information to the public. It's not so much a public involvement process. So the agency needs to disclose the project and the intent to do environmental studies at the beginning, and then it needs to, at the draft document stage, make that document available for public comment, which is usually a written comment process, and then to respond to those comments. So it's really the public provides input, the agency reacts. We're going to see in Section 106 that involvement of the public is really quite different. So CEQA and NEPA are very similar, not quite the same. They are handled separately by different lead agencies. So you have two different responsible agencies that are responsible for their own process. And so you really have actually two paths to be commenting on or to be preparing documentation for. Often we're finding CEQA is completed first, both because the project proponent or the state or local agency wants to make sure that a project is going to basically pass muster with CEQA before they really take it to that next level of getting the federal approvals. And then also sometimes some federal agencies won't consider a project until they know it's gotten CEQA approval, because they know how onerous CEQA approval can be. So they kind of don't want to invest that effort until they know that it's going to have CEQA clearance. So some problems of this include that if you have that staggered review and you prepare a lot of your environmental documentation in support of the CEQA process that comes earlier, that documentation might not satisfy the federal standards, might not be put together quite right unless you plan for that in advance. You might also find that if you go all the way through this CEQA process and you've identified the significant impacts and you've developed mitigation measures, well, when you then go through, especially the Section 106 process, it might not turn out that the mitigation that you developed under CEQA is going to satisfy the State Preservation Office and the consulting parties under Section 106. And so you might end up with different or additional mitigation measures. And so you have your mitigation programs a bit out of sync. But even more important, the public involvement and the involvement of interest groups really gets a little bit wonky, where the public and interest groups don't necessarily know how to most effectively engage with both processes. Here in California, those groups are pretty familiar with how to engage with CEQA, but I see a lot of times when we're doing these documents, they either disappear and don't know to stay engaged, or rather to re-engage when the federal process is happening, or they're engaging as if it's CEQA. And because it isn't, their voice is not as effectively heard. So that's part of what I'm going to be talking about today, is how to make sure that voice remains effectively heard. So when comparing CEQA and Section 106, a lot less parallel than CEQA and NEPA were. I pulled this flow chart from something that we've used a number of years, and it's provided by the California Resources Agency, who oversees writing the guidelines and such for CEQA. There are just a lot more steps where the agency is making these decisions about process and procedure rather than about resources. That's what that flow chart, I know you can't read the details, it's really more for effect of how elaborate the stepping through the process is. In Section 106, you basically have 4 steps. You initiate consultation, that's step 1, and that includes identifying the area of potential effect, the area you're going to study everything under. It also mandates identifying a plan to involve the public. And that's very key language that's in those regulations, is a plan to involve, not just to disclose information to. Step 2 is identifying and evaluating historic properties. So that's similar to CEQA, where the second step is to know what your resources are that could be affected by the project. Step 3, if you do have historic properties present in the APE, you assess whether there would be adverse effects. And then step 4, if there would be adverse effects, you resolve those adverse effects, either through additional exploration of measures to avoid those effects or minimization and mitigation. At each one of those steps, Section 106 guidelines require and expect that there's going to be public involvement. And throughout the process, the focus is on the resources and knowing what's happening to the resources, as opposed to really being focused on exactly how you're documenting and processing it. Here's another way of comparing NEPA, CEQA, Section 106, the ones highlighted in green, as well as really starting to give an indication that there are other federal regulatory processes, environmental regulatory processes that are happening at the same time. You know, we've talked about the fact that CEQA is multidisciplinary. There are 16 or 17 different resource topics. With Section 106, there's just the one, historic properties. But part of the reason we look at these others, you know, Endangered Species Act, Section 7, Clean Water Act, Section 404, Clean Air Conformity Act, and then just the concept of public involvement, is because those are all happening. Those also might affect the schedule of your NEPA, your CEQA, or your Section 106. Most agencies will not proceed with making their decision, their official decision, whether it's the record of decision under NEPA or the notice of determination under CEQA, until they have the biological opinion under the Endangered Species Act. So that's the kind of thing where you're also not going to go to the, under NEPA, you're not going to go to the record of decision until you have concurrence on your finding of effect in Section 106 and execution of your agreement document. There's no law that says that they can't reach those decision points, the end decision points under the other laws. Is really more of a best practice. Most federal agencies don't want to say that they are entirely complete with NEPA until they know that the Section 106 process or the Endangered Species Act process isn't going to change things and make them have to change the project and then have to reopen those other federal reviews that they had, you know, deemed closed. So they don't want to have to reopen consultation with SHPO under Section 106 if they find that the biological opinion required them to change the project, that kind of thing. So starting to get into some of the key differences to be aware of and how that affects how you can, either what kind of documentation, what kind of public involvement you're going to have, or how you can then you know, provide input to the agencies or even exert pressure to the agencies for maybe more historic resources friendly outcomes. So I'm going to skip, I am going kind of fast and I have had some coffee, but I'm trying to make up time. So, so CEQA is only applies to California agencies. It's multidisciplinary. Section 106 is federal and it is focused. The key one on this slide is under CEQA, there is no formal process or agency besides the lead agency who is required to consult about the evaluation of eligibility of resources. Under Section 106, it's mandatory that you consult with the State Preservation Office about the identification of historic properties. So that's a big difference. In CEQA, you know, with input from the public, with the requirement to have substantial evidence, which is meant to be prepared by qualified professionals, but still ultimately it is the CEQA lead agency who is deciding whether or not resources have been identified adequately. Under Section 106, SHPO has a really big role in that. The federal agency still is the one making the determination of whether historic properties are present, but the requirements to consult with SHPO bring in a very state agency with the state expertise in such things, so that changes that dynamic. More key differences include, right, there's no mandate to consult with OHP. In fact, OHP is never mentioned in the CEQA guidelines. They choose to only get involved if they think that there's going to be a really big precedent set A lot of preservation advocates will contact the Office of Historic Preservation to ask them to get involved or to weigh in or to have an influence on a CEQA-only project, and the OHP basically has to say, we can give you advice, we can empathize, but we don't have a regulatory role in the process. Like I said, very different under Section 106. They have a mandatory role in Section 106. In CEQA, there's really a broad range of resources that may be deemed a CEQA historical resource. Ken covered that a bit with California Register, National Register, even resources that are designated or on a local list or even just included in a qualified local survey. Section 106 is pretty cut and dry if it's eligible for or listed in the National Register. So we also see a lot of folks who try to get involved with the Section 106 process who are really advocating hard for a resource that has been found to be not National Register eligible. And it's tilting at windmills because the federal agency will never be compelled to consider those resources if there is already a determination that they are not National Register eligible. So that's a really good distinction to be aware of. In that kind of case, you're really better off investing your time in the CEQA process. Even more key differences. Like I said, in CEQA, the public is involved at the scoping stage and the opportunity to comment on documents, whereas in Section 106, there needs to be a full plan for involving the public along the way. That can include being invited to be formal consulting parties in the process, or maybe even signatory parties if an agreement document is going to be developed. Another really interesting one, under CEQA, phased identification is very much frowned upon. So this is the idea that Ken talked about deferral of mitigation. Same idea, CEQA frowns on the deferral of identification of resources. There was a really big legal precedent for this called, we refer to it as the Madera oversight case. And the courts basically said that if you haven't identified all of the cultural resources in this project study area, then you can't have disclosed to the public what those resources were, what the impacts to those resources would be, and what you might do to avoid those impacts. If you say that you'll do that after the environmental clearances and during project design, you've foreclosed the opportunity for the public to have input on that process of identifying what the impacts are. That's the entire purpose of CEQA, is to give the public disclosure of that information and the opportunity to comment on it. So that's why Madera Oversight said that deferral of identification of resources is not kosher with CEQA. In Section 106, there's actually language in the regulations that spells out how you would go about developing a programmatic agreement that can include phased identification and phased assessment of effect over the life of the project. That is still very strong, and the big difference between CEQA is that SHPO, with that agreement document, SHPO and consulting parties remain involved. They have, the federal agency is still beholden to them to involve them as those evaluations happen. There's no mechanism like that in CEQA to enforce the continued involvement of the public and interested parties. Ken talked about the thresholds for determining impacts a little bit, and I'm very much in the same camp he is of both noticing the nuance about materially altering in an adverse manner those physical characteristics, as if that means all of the physical characteristics that qualify a resource for listing. And the possible fallacy that a lot of lead agencies are making in interpreting that to mean that you only have a significant effect on the environment if the project would render the resource no longer eligible. I really don't think that that's what the creators of CEQA intended. I think it's an easy out. We know of some lead agencies who have adopted that as a threshold. And we know a lot of preservation advocates who basically argue that the finding of the document should be that there's a significant effect because the resource would be no longer eligible. I think that's too short-sighted, and I really caution people about that, because if you say that the project rendered it no longer eligible and the project proceeds, then the next time a project comes up, there will be the precedent, there will be the legal documentation that that resource is no longer a resource. And so that future project can do whatever it wants. I don't think that was ever intended. Section 106 has a much lower bar for arriving at the conclusion of adverse effect. It just says any of the characteristics. It's a little more challenging because not every project that makes a change to a resource has an adverse effect. It still needs to be one that is, a substantial adverse effect. That's not even the right language. Anyway, it's a lot more challenging. And it's figured out through consultation with SHPO, with the lead agency, and with your consulting parties. And again, that's a good thing because you're getting a lot more voices in the mix, and you're also starting to set the foundation for how you're going to talk about resolving the adverse effects. In CEQA, you have at least 4 different impact conclusions you can come to. No impact, less than significant impact. You also see people use significant impact with mitigation, or significant unavoidable impact. In Section 106, it's a little more clean cut. You have an equivalent, no effect, or it's no adverse effect or adverse effect. There's no concept in Section 106 of the idea of adding mitigation and thereby reducing it to no adverse effect. And a lot of people in CEQA are used to that idea that you recognize it had a significant effect, but you applied mitigation and you reduced it to less than significant. There's no corollary to that in Section 106, and it's okay. In Section 106, you arrive at adverse effect, and it's not a project stopper. It's also not it's not a fait accompli for the resource either, because when you're talking about resolution of adverse effects, you are still going to be talking about options to avoid those adverse effects. In CEQA, developing mitigation is done entirely by the lead agency. It's their choice about what they're going to consider adequate mitigation. Section 106, the adequacy of mitigation needs to factor in strong input from the State Preservation Office as well as other consulting parties. And so there's just a bit more exposure of the lead agency about what they're going to do and what they're going to deem sufficient. And so you often end up with a little bit more robust positive treatment of the resources. Okay, I'm going to make this a little bit quicker word than this mini novel on the screen about integration versus coordination. There's a citation there about guidance that was put out in 2013 by the Advisory Council on Historic Preservation. They oversee all things Section 106, and the Council on Environmental Quality. They oversee all things NEPA. They got together, put together a document advising and guiding on how you would actually fully integrate those two processes. They talk about when you might substitute one for the other. Usually it would be substituting Section 106, substituting NEPA for Section 106, where all your NEPA documentation and your NEPA public involvement would satisfy 106 requirements. And it's a really good read for understanding how those two laws relate to each other. It even basically concludes that it's a big challenge to integrate the two. And I know here in California, our Office of Historic Preservation, also known as SHPO, has tried it a couple of times and has found it to be maybe not in the best interests of their mission, which is to encourage the preservation of historic properties. In the 2 cases I'm aware of when I've talked to staff, the main things that are missing are the public, well, really the main thing that becomes missing is the public involvement and the involvement of SHPO and preservation interests when it comes to resolving adverse effects from their perspective. Because like I said, the mitigation step is done entirely by the federal lead agency under NEPA. So that's one of the reasons that it just doesn't feel as right from the folks who are responsible for Section 106 when you fully integrate and satisfy 106 through NEPA. So some things you can do if you want to coordinate them well. When you're defining the project area under CEQA or NEPA, be sure to be thinking about the Section 106 area of potential effects, which might be drawn slightly differently because of how the 106 process plays out. And part of that is, like I said, you have different lead agencies under CEQA than you do under NEPA and 106. The jurisdictions might be different. So for example, if the federal trigger is Section 404 permitting, Section 404 is about waters of the United States. And so the jurisdiction is only around those waters. If you have a large project that crosses some waters of the United States, but also crosses some areas where there are none mapped, then the Section 404 permit wouldn't apply to those areas that don't have the waters, and therefore the Corps of Engineers APE would not include those areas either. The CEQA study area would include all of that. So you have different jurisdictions leading to different study areas. Record searches, when you're gathering information about resources that have been previously identified, be sure to be expanding beyond just the ones that qualify as CEQA resources. Also be thinking about the consideration of cumulative impacts. So if you're getting started on the Section 106 process, you might be, even though we do cumulative analysis in Section 106, we do it slightly differently. It's not quite as rigorous, I would say, as it is under CEQA. Your resource study area for cumulative under CEQA is often going to be larger than what we consider under Section 106. So you want to be taking all that into consideration when you decide, where am I looking to find out whether previous studies have identified historical resources. Consultation, I've touched on that quite a bit. You want to extend the invitation to all who might be consulting parties later when the federal processes kick in. You want to clearly understand the differences in tribal consultation between state law, where AB 52, which Samantha will be talking about a little bit later today, establishes a certain process, versus the Section 106 tribal consultation requirements, where they are only mandated to consult with federally recognized tribes. A lot of federal agencies will expand that and consult with other tribes as well, but some of them really take refuge behind the fact that the law only requires them to consult with federally recognized tribes. Technical reports, always a good idea to try and make your technical reports really one report that could be used as a basis for CEQA or NEPA and 106. The big distinction there is to make sure you apply both the California Register criteria and the National Register criteria. Also, clearly indicate those resources that are, CEQA only, by virtue of being listed at a local level or on a qualified local inventory, from those that satisfy the Section 106 definition. Like I said, those ones that are only local will not be Section 106 historic properties, unless you've reevaluated and decided that they also meet National Register criteria. The technical reports really are most useful if they clearly define the character-defining features. Ken touched on that earlier, but the way we analyze impact is whether or not the project would impair those character-defining features. If they aren't spelled out, it makes everything messy when you go to try and make your impact justification. Impacts analysis, when you're coordinating state and federal, they're all based on the project's potential to reduce historical integrity, its ability to convey its significance. But the impacts and effects conclusions might not actually come out the same. It's pretty, I wouldn't say standard, but it's entirely possible that you would end up with a project that would have a less than significant impact under CEQA that has an adverse effect under Section 106. And that is okay. Both processes have been done well, and actually the resource might end up with the same exact outcome of its state after it. It's just how you got there and how each lead agency imposed mitigation or imposed a consideration of alternatives is just different along the way. A lot of people get really hung up trying to force a CEQA finding of significant impact if they know that it's heading toward adverse effect under 106. Again, that's a little bit of tilting at windmills. You can achieve the same outcomes without getting too hung up on that particular piece of it. We advertised that we were going to talk about Section 4F as well. I'm going to try to go even faster through this because it's a very narrow part of the federal environmental reviews. Let me see how well I've done with, I've done pretty well with catching up with time. So Section 4F is part of the Department of Transportation Act from 1966. So actually it only applies to federal transportation agencies. So that's aviation, federal highways, federal transit, federal railroad administration, etc. It used to apply to the Coast Guard, but they got put under the Homeland Security Department, so not Coast Guard anymore. And the thing that makes Section 4F the preservationist friend is it has the most rigorous standard for whether or not an agency can proceed with a project if it would use an historical resource. A DOT agency can only proceed or approve a project that uses a Section 4F resource if there are no prudent and feasible alternatives, and if it incorporates all possible planning to minimize harm. That's a really high standard. And so basically, especially Federal Highways Administration, they do everything they can to avoid having a Section 4F use. They will redesign the project. They will even abandon a project to not have to go through a full individual 4F evaluation. So that is really good to know. One of the downsides that I will jump to, I think it's on a later slide, is there's actually no mandated requirement for them to have public involvement. So how would you know to push that trigger and to put pressure on the agency if there's no real transparent public involvement process? One way is that a lot of agencies go ahead and document their Section 4F in the NEPA document. So look for that chapter when you're giving your NEPA comments, provide comments on the 4F chapter. That alerts the agency that they need to consider that for 4F. It also is then in the public record, and when other agencies get involved with consulting on the 4F findings, they will see that. So the process is very similar to 106. You determine whether 4F resources are present. You determine whether project uses 4F resources, and that basically means incorporating it into the transportation function. You just determine how to process it, whether you're going to have this idea of de minimis, which basically means that it's of such minimal significance, the use is of such minimal significance that you can say, we don't have to do a full individual evaluation, or whether it needs an individual evaluation. And then once you've made all your findings, you implement the compliance requirements. So 4F is kind of a sweet spot in between. We talked about how CEQA and NEPA have about 16 or 17 different environmental topics to address. Section 106 only has one. Section 4F has 4. So it's historic sites, which they define to be those eligible for or listed in the National Register. But then it also has publicly owned and publicly accessible parks, wildlife refuges, and recreation areas. So those are the resources 4F is concerned with. Only concerned with historic sites that are eligible or listed in the National Register. Interestingly, it's not concerned with archaeological sites unless the archaeological site's primary importance is derived from being preserved in place. Most archaeological sites, the reason they're important is the data potential that they have. If that data potential can be retrieved before the transportation project would go in, then they're able to say that there would be no use because the data potential is not obliterated by the transportation use. So it's very rare. The 4F training that I've done, the folks from Federal Highways Administration basically say that you know, somebody who'd been doing it for 35 years said he'd only known of 2 cases he'd worked on that archaeological sites were a 4F resource. I mentioned bullet number 3, the coordination requirements only involve the agency with responsibility for the resource and the DOT agency. There is a nexus between Section 106 and Section 4F. Projects with a Section 106 no adverse effect can automatically be considered to be eligible for processing as de minimis. But the reverse is not always true. A project with a Section 106 adverse effect is not always a Section 4F use. That has a lot to do with the idea of whether it's actually going to incorporate the resource into the transportation function. Ooh, I did it. We are almost on time. So having blown through that so quickly, are there any questions? I think we have little time to entertain that and be able to still stay on course. Microphone coming up to a questioner.
Can you speak a little bit about how to get onto a consulting party?
Okay. A couple of ways. So actually, there are so many ways where to start. So if the federal agency does a scoping meeting at the beginning of NEPA, hopefully they also have a little table at that scoping meeting saying that Section 106 will also be done. Unfortunately, a lot of times they don't. They haven't actually started thinking about 106 until their NEPA consultants or their NEPA staff tell them, hey, we also have to do this. So go to the scoping meeting and ask how you get on the list of parties to be included as interested or consulting parties. If the scoping meeting is challenging, maybe they noticed it really soon before the meeting and you didn't have time to plan for it, contact the federal agency. There should be contact information in the notification, the actual notice of how to contact the federal agency, point of contact for that project. Let them know you want to be. Federal agencies typically these days, those who do right by their Section 106 obligations will typically allow anybody who expresses interest in being an interested party or consulting party to be included as such. And I put that caveat on it because there are still enough federal agencies who consider the mission of their agency to be paramount to really needing to do a thorough job of Section 106 consultation. So aside from those agencies, the ones who really have a good 106 program will include people. There's no need to express it only at those meetings. At any time, if you express that you want to be a consulting party, the agency really should strongly consider it. And there are different categories of consulting parties. So you might be an interested party. The federal agency might hold a bar there that you demonstrate an interest on the part of the organization that you represent, that you are representing a preservation organization and you want to be a part because you have, sort of have a demonstrated interest in the resources being affected. If you're an individual, then you're requesting to be part of the process as a member of the public. Like I said, the 106 regs speak directly to the need to involve the public. So at any of those levels, you should, they should invite you to participate at one of those levels. They might have different amounts of involvement that they grant depending on those different statuses. It might be that you're just part of the group that is distributed all the information that is developed along the way in the 106 process, or signatory parties for sure, and most consulting parties are invited to, if there are any workshops or even sort of small group workshops once you get to that point of having identified adverse effects and needing to come up with ways to resolve them. There might be the more focused group, really conversations where you gather together and you talk about what are the possibilities here for resolving these adverse effects. The general public aren't necessarily invited to those, but if you have been recognized as a formal consulting party, you will be at that table. So it's a really good thing to seek out that status in a 106 review.